It's a great pleasure to welcome you here at this important European cyber diplomacy dialogue. So the topic of today is, of course, very important to start our discussion, and it's international law and sovereignty in cyberspace. Professor Koskenniemi.
Thank you very much. I would actually like to speak standing up. I hope it's possible here. So I'm one of those professors who get bored if I sit down speaking. So I'm a generalist public international lawyer. I started my career with the Finnish Foreign Ministry. It was said I only worked in the legal department for 17 years, and in that context did mostly UN-related stuff, sat in the UN Security Council when Finland was there, etc. Then became an academic, first in Helsinki. I have a permanent position at NYU, Melbourne, other places. I'm a generalist, I was, I suppose, invited to do this opening lecture in order to give an overview of somebody who is not a cyber person. An overview of by that person of the materials that have been produced recently in the cyber debates, in debates about cyber diplomacy, and how I see it. Is it a meaningful international legal debate that's going on? What could or should be done in order to make it meaningful? And how can we think about some of the basic notions? Okay, so we start with the idea that cyber activities, whatever they are, and you're going to talk about this, and I'm going to say a few words, that they should be regulated in one way or another. How does one go about in international law to regulate? There are two, broadly speaking, two different kinds of regulatory techniques in which we can try to persuade people in these ways. One we could call rules per se, and the other one we could call standards. Rules, I call them those kinds of directives which have bright lines, which are clearly applicable, which are easy to use, are very predictable, and give security to people moving around them. What could be those kinds of rules? Well, traffic rules are like that. If it's red light, you have to stop. There's no discretion, as we say. You have to stop. Whether or not you're taking somebody to a hospital because they're ill, or you have to stop. Maybe you still have to drive there, but you get fined nevertheless. You say to the police, well, it was an emergency, and say, well, yeah, but, you know, a rule is a rule is a rule. Rules are therefore necessary for social life. They create predictability. We can trust each other. We abide by the rules. Now, but rules are often really problematic. And especially in international world, they are problematic. Because they apply also to cases that the rule makers actually didn't come to think when they enacted the rule. And the rulemaking always takes place by reference to past practice. We legislate in order to, because we remember stuff that happened in the past. Rules often bind us in situations where we don't want to be bound. And therefore, we often insert in the rule itself broad expressions such as act in a reasonable way. A contract is binding if it's made in good faith. There are lots of discussions in international law that turn around the choice between rules and standards. We need those standards, words such as reasonable, good faith, as appropriate, and so on. We need those because we don't want to be bound down by rules when the rules come and hit us in the face. Give me an example. Okay, here is one. This would be Article 51, it's a famous example among international lawyers, Article 51 of the United Nations Charter on self-defense. When the drafters of the UN Charter were thinking about situations where we could allow people to use force, they wanted to make that opportunity as narrow as possible, the threshold as low as possible, and the criterion for the use of force as clear as possible, so that there would be no misuse. So they wrote into Article 51 on self-defense that you can engage in self-defense if an armed attack occurs. So that's a really rule-like provision. You can go there out, it's an empirical fact. Did an armed attack occur or didn't it? And so everybody congratulated themselves in San Francisco. This is now really binding. The problem was, you see, that during the League of Nations, in the covenant of the League, what was prohibited was going to war. But what's war? The Japanese had been a year in Manchuria before the League of Nations noticed that there was a war going on. They had to send a commission, the Lytton Commission, to Manchuria to see, well, actually, the Japanese said, no, it's just a police operation. What, war? No, we wouldn't. So it took a year. And of course, the experience with Ethiopia, similar. So now they wanted to have clear-cut thing, red light, if an armed attack occurs. But 5 minutes thereafter, they came to think, well, but what if I can only prevent the armed attack by striking first? What if it's a nuclear weapon, for instance? Do I have to sit here in Washington and wait until the armed attack occurs? Well, I'm sorry, but then it's already too late to self-defend because I'm dead. And so, in a number of cases, fortunately not real cases, but hypothetical cases, including in the International Court of Justice, lawyers have said, well, you can't read that so literally. You have to take into account these situations that you can only defend yourself before the attack has occurred. At the time when I was in the foreign ministry, we speculated about, at that time, Euro missiles. And whether, a country like Finland would have to wait until a Euro, or the contrary to Euro missile, might fall, or might we have to actually strike first? And I remember I was there with our military, and I was saying, well, this is what the Charter says, but, we can't take it so seriously. They were a little bit shocked for a couple of minutes, but then they realized that so the UN Charter is not a suicide pact, as we say. So we didn't conduct it in order to shoot ourselves in the foot. So now everybody accepts that you don't take it literally. So if the attack is imminent, there's no other way, what used to be a rule became a standard. And standards are really good because they give us the opportunity to think hard about the situation. They don't generalize. They look at the situation, allow equitable adjustment. Now, however, there's a problem because they are binding, as I put here, only more or less. They allocate much decision to the law applier. The idea is, of course, that the legislator acts a rule, and therefore the legislator, the United Nations member states, for example, they can control what happens out there. But if the provision has the form of a standard, then they just say, oh, you decide, because you are reasonable men, you International Court of Justice, you committee, whatever, Security Council, you use your discretion. Well, in some situations, that's a useful deference. In other situations, it isn't. So that's the basic set of choices we have when we write something like a Tallinn manual. We would want really to regulate, but then when we think about these situations, it's kind of unpredictable and the technology changing, so we have to insert words when reasonable, when appropriate, etc. So here are some examples of standards from the Tallinn manual. Tallinn Rule 7, the principle of due diligence, which is already a standard, requires the state to take all measures that are feasible. Feasible in accordance with whom, in the circumstances, as determined by whom, serious adverse consequences. Serious for whom, and who decides? The second Tallinn Rule, a definition of a cyber attack, so now it's really hardcore. Cyber attack is a cyber operation that's reasonably expected to cause injury or death. So an attack on a country is, a bad thing if it's reasonably expected to cause some little damage or more damage, discretion. So Tallinn Rule 73, the right to use force in self-defense arises, and this is what I was telling you about, if the attack is imminent. and it's further subjected to requirement of immediacy. If you are the one targeted, then of course the immediacy is now, but if it's somebody else that's being targeted, and maybe it's your adversary, it's not such a great problem if that person is targeted. Actually, it's kind of, well, I don't go there. So, and countermeasures, the famous idea of countermeasures into which the idea of proportionality has been written. So, the 500 pages of the Tallinn II manual, which I for the first time in my life opened a week ago, is full of these kinds of statements. My point is not to ridicule them. My point is to say that there is something inevitable and obvious about this, and that it's not a problem that can be resolved by more words. The more words, the less soluble the problem is. So when the Tallinn manual moved from the 250 to 500 pages, it became indecipherable. And I would say, as a generalist international lawyer, having done almost everything, done something in almost every field in international law, I find this completely inoperable as a legal instrument. Okay, so how to think about rules and standards? So rules work when there is no solidarity in the community in which there's rule, because you don't trust anybody. So a rule is a rule, the red light. You don't ask drivers to think for themselves. If you did, of course, the code of the road could be written, well, all drivers should behave reasonably and in good faith and think hard about what's safe and what's not. That could be, in some sense, that is what the rules of the road want to do. But we can't trust each other because, of course, I can always reason in a brilliant way, but they can't. So suspicion is high. Rules are good because they bind, they bind. So here is the rule, no question. And they work well when the matter is a routinized behavior and not a rare occurrence. After the Kosovo bombings in 1999, I participated in a number of debates, including under the UN Secretary General. I was also a member of a Danish and a Dutch expert committee that looked into the possibility of regulating humanitarian intervention or responsibility to protect, to have rules on that. Because if the law only says, well, you can use force if there's a large humanitarian crisis and no other alternatives are available, that's too much of a standard. That's too open-ended. That allows everybody who has the means to intervene. And so we wanted to figure out whether it's possible to find a rule that would really bind the Americans and NATO. Because, Finland wouldn't intervene in the Crimea, for instance. But so the rule here concerns only a few people. And it concerns things of great importance, massacres, atrocities, maybe genocide. So can you regulate a genocide by rule? Let's say you have a rule. What could be a rule that would clearly, like a red light, regulate genocide? Here would be a rule. When 1,000 people are killed, then the holy force can intervene. 1,000. That would be an excellent rule, because it's a red light. 1,000. Now, why didn't we enact something like that? That's just an example, an extreme example, of course. But it shows you how we actually don't want rules when it's a matter of great importance. Now imagine that the UN General Assembly once enacted that rule. What would it lead to? Imagine that there's a tyrant who wants to get rid of a minority population because she wants to set up a holiday resort where they live. And she turns to her legal advisor saying, well, I just want to annihilate those people in order to have my pool set in where they've lived for the past 5,000 years. What would the legal advisor say? The legal advisor would say, well, Madam Tyrant, just last week this international convention was concluded which says that if 1,000 are killed, then there will be a holy intervention. But then the tyrant will turn to the legal advisor and say, but you're the legal advisor. Your task is not to tell me what I can't do. Your task is to tell me what I can do within the limits of the rules. And then the legal advisor would say, well, actually, this is very easy because the rule is so clear. So this is what I suggest to you. You go to every little house of that minority population, you take the blue-eyed under 3-year-olds and you cut their heads. And when you come to 999, stop. And I bet that they will have left before you've gotten to 999. And now notice, the killing, and the intervention force is there, just outside the boundary. They are counting. 1, 2, 3. They have all the weapons, It's a really massive military operation. They're preparing 5, 6, 7. Now, of course, that's ridiculous. What I'm pointing out to you is that in this case, in this hypothetical, where we have a rule, and the rule tries to regulate a single situation of great importance, then the rule is actually less important than the necessity of acting now. So a responsible general of the Holy Military Force would say, stop counting, go in. And of course the rule would be stupid. It's the rule that would kill those 999. Okay, so rules cannot be really used when it's a single big thing, because the rule in international world is rarely more important than the absolute necessity of acting now to protect some interest that's really vital. Why would I let the rule destroy a value that's so important for me, that maybe involves lives, great economic losses, when the international world isn't a world where we bow our heads regularly in front of rules? So we don't enact rules in those situations. A rule such as red light produces a good social consequence because it's a routinized behavior that's being regulated. It's true that some people actually may get fined, even if reasonably thinking that was a little bit of an injustice, but those injustices take place in the margins of the rule, whereas the great social benefit is the routine that now operates in a credible, predictable, and safe fashion. So in the international world, these matters are not matters of routine. They are single incidents, and therefore we need discretion. We don't have solidarity. So ideas about reasonableness, good faith, when it's appropriate, they work well in a world where there is solidarity, when we can expect that the law applier thinks about the world a little bit like we as legislators. So we can say, let the judges decide, let the committee decide, because by and large they are, they think like we, etc. We trust them. So here is a typical regulatory situation where you cannot use rules. This is an article from the UN Convention on Non-Navigational Uses of International Watercourses. That convention provides that there shall be a principle of equitable utilization. So that's a standard. That's the main rule of the main directive of the convention, and it is formulated as a standard. It's not formulated as a rule because there are different watercourses in the world, and you cannot just from Geneva or from New York, say, well, this is how you should act in respect of some particular river. But you can say that you should use the river in an equitable fashion. However, everybody, when that convention was concluded, realized that that's just too open-ended. If the convention tells people that you should be equitable, what do these people learn that they didn't know before the convention? So the regulatory technique then is to give examples. And in this case, the standard points to a weighing scale. So it's a balancing exercise here. In order to determine what counts as equitable utilization, you take into account all relevant factors and circumstances, including 1, A, B, C, D, E, F, G, So you take into account everything. And then in the application of this article, you enter into consultation. You see, it presumes that there is a solidarity between the riparian states, between the watercourse states. So whether that assumption is justified, I don't know. I'm thinking of rivers between Finland and Norway, and then rivers between India and Pakistan. And, well, cooperation in one context clearly is more easier than in another context. I'm particularly struck by paragraph 3. The weight to be given to each factor is to be determined by its importance in comparison with that of other relevant factors. Now, here are serious diplomats who have sat years in order to get to this convention. All the factors have to be considered together and a conclusion reached on the basis of the whole, and the rabbit comes out of the hat. Again, the point is not to ridicule multilateral treaty making. The point is to say, well, it's really hard. And the diplomats who come to those situations have always 2 instructions with which they have to approach the regulatory matter. Sometimes those instructions are written. Most of the time they are not, because they are diplomats, you are diplomats, I used to be one. So you know what these 2 instructions are. What are they? Well, here's the first instruction. Whatever you agree to, don't agree to anything that might strike at your state in some future circumstance. And now when you have that inscribed in your mind and in your professional practice, then you always want to leave the door open, at some corner, so that, because you don't know, the future is different from the past. And your country might be targeted by environmental pollution, your river, or by an armed attack, or maybe by a cyber attack. And you don't want to prevent your country from taking action, whatever action it needs to take then. So instruction 1 says, make it open-ended so that we can always save ourselves. What's the other instruction that everybody has? It's this. Try as hard as you can to bind every conceivable adversary that you have. Okay. So it has to be really binding. Red light. Now when the schizophrenic diplomats sit there around the table and try to think with those 2 instructions, on the one hand, leave as much room to maneuver for my state, and bind as hard as you can every other state. If you have both of these in your mind, then something like this will emerge. And when I read the 500 pages of the Tallinn manual, I could not think of anything else apart from this. I come to my second point. I have just 3 points. So this was what I wanted to say about how to regulate. Rules or standards, pluses, minuses. It's hard, So the other thing I want to say is about thinking of something as a legal regime, as a, let's say, cyber regime. I come to this question because now, having become a great expert in cyber in the past week, I've read that there is a disagreement between the West and then China and Russia that has to do with this question. It has to do with whether there is a vacuum in the international legal order and we need a regime, a new regime. Or whether, public international law as it is can do the thing. Now, in the past 30 years, that question has very often arisen. And it has been dealt always in a very, always in a manner that resembles, or in a similar way. So, when human rights emerged to the international scene, human rights lawyers said, well, public international is just too state-centered. And we have different values, different concerns. Human rights law and public international law have nothing to do with each other. Human rights is a regime, so they set up special bodies such as the European Court of Human Rights. And here is a famous quote from the Loisidou case against Turkey. This has to do with northern Turkish situation, a Greek who had lost her property there. Turkey had made a declaration saying that the European Convention on Human Rights should not be applied with respect to Northern Cyprus. And this woman from Northern Cyprus comes then to the European Court of Human Rights and says, and files a case against Turkey. The court is now confronted with how to understand the Turkish denial of jurisdiction from the European Court. In public international law, there are standard ways of understanding reservations of this type. For example, in public international law, under general law of treaties, you either accept the reservation and the state is a member of the treaty with the reservation, or you don't accept the treaty, in which case the state doesn't become a member at all. Now here, the European Court wanted to avoid both of these things. It wanted to give justice to the Greek complainant. But that was possible only if it accepted that Turkey had become a party to the convention and erased the Turkish reservation. And that's what it did. But in order to do that, it had to say, well, you know, human rights is just wholly different from public international. We haven't heard about that. So treaty interpretation, no. You have to understand that we are a special regime. We are human rights, not public international law, and therefore we act differently. When the WTO was created in 1994, the drafters of the WTO treaties were very keen that in the WTO organs, they would only apply WTO treaties, and not like environmental treaties or other international law treaties. No. It's just, this is a trade operation. And we are trade experts. We don't want those extraneous arguments about environmental things or human rights things to intervene. And that's why they wrote in the Dispute Settlement Understanding, this article, recommendations and rulings of the dispute settlement body cannot add to or diminish the rights and obligations provided in the covered agreements. So that's technical wordings for saying we are a special regime, we are a cyber regime, and cyber principles apply. We are a trade regime, so trade things apply. So what happens? Well, of course, these bodies have people who have varied experience. And in the European Court of Human Rights, in another case where it seemed to be useful because of the political leanings of the court or its human rights leanings, it insisted that, well, you know, somebody had made an argument that human rights is different from international law. But the court here says, no, the convention cannot be interpreted in a vacuum. It should, so far as possible, be interpreted in harmony with other rules of international law of which it forms a part. So which way do you go? Is human rights different or isn't it different? Here is one of the first decisions of the appellate body of the WTO, in which it started to interpret WTO agreements. And so it said, WTO agreements should not be read in clinical isolation from public international law. Now so ethnographically and politically, it's really interesting. See, so who gets into these bodies? What are their priorities? What's their training from background? How do they see things? There isn't a way to say the one is right or the other one is wrong. These are strategic choices that institutions make. They sometimes want to withdraw, and, oh no, I have nothing to do because I'm special. And at other times to say, of course I have jurisdiction because I'm just part of the general. So there are strategic choices. You act under existing law. This is the American, the UK, the Western. So, cyber law, there's no need for a cyber law because the international law already covers. And that's a position that is strategically useful because there's already much experience. I am producing some of that experience in front of you in public international law, which clearly is applicable to cyber activities. Coherence with the rest of the law so that human rights, trade, environment, cyber, that they come together in a coherent way is valuable to some extent. The problem there is that if you accept it, then you're bound by earlier actors and the way the system has developed in the past. Now that's, of course, the West has an interest because the West has developed international law. International law is a European concoction with some American details being put in. And of course, if you are a Chinese or a Russian person, you would not want to sell your soul to that set of institutions. Instead, you say, no, we set up a cyber regime. Because in that new cyber regime, with these new, technically complicated, well-polished rules, I am now the master. And those people who created that old law, they must shut up. We can now do this all from scratch together. Now, we have been in exactly that situation in the 1960s, when after decolonization, new states were saying, we are not bound by the old law. It's tabula rasa, they said, in the UN General Assembly, in a huge number of articles, essays, books that came out in the context of the international legal debates on decolonization. Are new states bound? Aren't they bound? Now we have some experience. To some extent they were bound and had to accept it. There were some exceptions to that. Because they were weaker than the West, the exceptions were really small. And by and large, they had to take the international legal and diplomatic system as they found it. It was changed only in the margins. So, to create a new regime, to imagine that cyber is a regime of its own, gives freedom to the cyber people. No automatic application of anything old. Most things are still unregulated. We can fight it out. It's not that we have to accept some war that's been waged before we were born. We can now fight it out. The thing is, it just may not succeed. Because, as we saw, both in the European Court of Human Rights, in the WTO, and in any other circumstance I can think of, usually the old tends to prevail. The world is made in that way. This is a couple of paragraphs from the International Code of Conduct for Information Security that the Russians and the Chinese and Kazakhs and some others presented to the UN General Assembly. And you can so clearly see here the effort to create a special regime in which new values, new objectives could be consecrated as the official values and objectives of this new system. So, for instance, the operations should comply with the Charter and is in regard to every country, respect the diversity, history, culture, and social system of it. And the idea is to curb dissemination of information that incites terrorism, and those two words, separatism, so China, extremism, so Russia. And none of this is, of course, in the UN Charter or in any other Western accepted traditional law. Then there are these couple of other provisions there to respect the rights and reputations of others. I'm doing a little bit of historical work on the history of diplomacy, and in the 18th century already they thought to refer to reputation is really problematic, and we need to get rid of that. National security, public order, public health, or morals. Well, you understand, so these are strategic choices. So if I'm able to create a cyber regime, then I am the master of that regime, and I can ignore what the general law says. My third point is just a few points about the language. So sovereignty seems to be a big thing. International legal thinking begins with sovereignty. When there wasn't sovereignty, there wasn't international legal thinking, nor international legal rules. Now, sovereignty is important, but it's also really, really indeterminate and unhelpful. Because it's always two sovereigns that meet each other, that interpret their sovereign rights from their own perspective, and they clash. So in terms of use of force, the one who first uses force will always say that I have a sovereign right to determine when it is a situation that calls for self-defense. And the one being attacked is, how can you say that? So my sovereign determination is that my territorial integrity and political independence have been violated. And that's the end of that. There's nothing more to be said. You can't derive from sovereignty some miraculous thing that resolves your problems. Sovereignty is the problem, it's not the solution. Then there's the question of state responsibility and attribution. That also seems to be all over the place. It used to be there when I was participating in the early stages of the creation of international environmental law. And we were worried that most of the polluting activity that across boundaries comes from private activities, private industries, private industrial. How can we regulate? The states will say, I have nothing to do with it. Why should I pay? Why should I be accountable? Because it's these industries. How do you attribute? And then we came to this miraculous word, due diligence. Okay, so a state should be diligent. A state should exercise supervision within it so that it sees what goes on there. Now, what kind of supervision? The third world countries were immediately saying, well, you know, half of our territory is completely unpopulated. We don't have the resources to send people to see what happens in that remote village, for instance, if they pollute a little bit of your land. We have bigger problems, frankly. And, you know, that's not an unreasonable position. It's a standards position in which you can deal with it once there is solidarity between you and them. And you say, okay, so we don't apply it to you because we understand your situation. But if there's not solidarity, then you just want to hit them. Due diligence. And then there's this thing, customary law. So I cannot imagine a statement about the length, the duration of customary law that I wouldn't have seen in the course of these years. It's one of these amorphous things that has always been. So lawyers revel in thinking about what is customary law. It has these two elements, practice, opinio juris. There must be something must have taken place in the past, and people must think that what happened in the past must be because a legal obligation committed us to acting in such way. Custom or past practices are elevated into the level of being a customary law if the people who participate in that practice think that they are bound to participate in that practice. The well-known problem there is that why would your conviction that something is already binding make that something binding? So your mistake of thinking that when you followed this, you followed the legal rule, that then creates the legal rule. Well, it's just, no, law is a vocabulary. It's a technical vocabulary in which you can do things. You have interests, you have ideas, values, a project. And then you turn to your lawyer and you say, well, dear lawyer, how can I get there? And the lawyer produces that set of words to you using expressions such as I put there. This is my last slide. But I think it has to be said. It can't be said often enough. It's not, what is international law? So I am a professor of international law. I'm a reasonably famous professor of international law. I have no clue. If I take basic literature, if I talk to my colleagues, I can hear them, I can read them, or behind those readings and these vocabularies, different kinds of understandings. We can think of it as a regulatory instrument, surely. And that takes you some way, but I've already tried to demonstrate to you that as a regulatory instrument, it has some specific aspects to it, because it seeks to regulate in a highly hostile environment, in which everybody is kind of dubious about the motives of everybody else. It's not a national community that's being regulated. And in some ways, regulation like the Watercourses Agreement, it may be helpful in some contexts, but it's not helpful in other contexts. International law is also an instrument of what we've now learned to call lawfare. This is an American neologism which refers to the use of law as part of warfare. And I'm very familiar with this, and I've demonstrated to you a few ways in which we as lawyers try to hit our enemies and defend our clients. We use it by these words. We from the mass of expressions, construct a kind of defense of our client, our country, whatever it is that we need to defend, and then use that mass in order to attack our adversaries to get the best deal possible, etc. The Americans, of course, use the expression lawfare when they want to say all kinds of pacifists and leftists are critiquing American action in Afghanistan, etc. Why should we take their legal argument seriously? It's just lawfare. They are just using this as an instrument to hit back on us. And of course, they are not wrong, but they are doing the same thing all the time. So regulatory instrument and lawfare come together in some complex way, which is really hard to understand. Many people, especially from the political science side, want to think not law, not so much as norms, as regulatory rules or principles, but as a means of communication, means of cooperation and learning. So law is something that brings us together. We talk about it, and we come to understand each other's objectives, each other's values, and maybe fear each other a little bit less. And maybe the atmosphere of solidarity within which rules can operate can gradually be created through legal debates. And this is not completely wrong. There is some really sophisticated recent political science literature on the ability of law kind of secretly or behind the scenes doing this kinds of socialization work. And certainly all international lawyers we are a really sociable and friendly bunch who feel a lot of solidarity among ourselves, especially when we fly to these wonderful places like Florence and give these talks. So we feel it's great. Now, international law is the thing. Not everybody thinks that way. Then there is a very well-established, serious, practical sense of international law, as that's what courts do. And most of us, in one way or another, as lawyers, have been trained to think in that way. International lawyers may be slightly less than, say, contract lawyers or administrative lawyers, but we too. So we too read the cases from the International Court of Justice, the European Court of Human Rights, and in some sense we think that that is the core, that is the heart of law. And then the law, when we think about it, it radiates towards the margins from that core, and somewhere there in the utter margin is international law, which is it law, is it not? Well, we can have conversations over beer about that. Those conversations are ongoing and they have never ended. Same, contract lawyers don't have that conversation. Administrative lawyers, judges in international bodies don't have that. Sometimes when my colleagues ask me, well, how do I know international law exists? I say, well, I'm an international lawyer. I exist. There is no better evidence of that. And I think that's where I want to end. Thank you very much.